welcome to Legally Speaking with me, Tarun Nangia. Justice Sanjay Kashan Kaul with the Satyendra Kumar Antil judgment has taken a big pro-liberty stand. And that is what we're going to discuss today. This is very important because investors from all over the world, when they look at India as a destination, they also look at the fact that what would happen if they are, in a sense, booked in a case. Would they have to spend months in jail without even being convicted for it? Or would, whenever all documents is documentary, even then they have to spend time behind the bars? Because in India, many times it's very difficult to get bail. Courts are reluctant. That's why this judgment is very important. We also know that the Supreme Court is monitoring how the various states are implementing it. I was reading the record of proceedings, and senior advocate Siddharth Luthra is amicus in this case. That's why you see the Supreme Court has taken this issue with a level of seriousness which it merits. And that is why it should be discussed. And also the widest possible audience should know this. I have a very eminent panel who will discuss this with me today. I have with me senior advocate Saurabh Kirpal, who joins us. Good to see you, Mr. Kirpal. I have with me senior advocate Pramod Dubey, who joins us. Good to see you, Mr. Dubey. And Neha Nagpal, founder partner from NM Law Chambers. Good to see you, Neha. At the outset, let me request senior advocate Saurabh Kirpal that in the first 2-3 minutes, if you could lay the ground of what was India before this judgment of Satyendra Kumar Antil, what has transpired, and how do you foresee the implementation?
Right. See, the judgment of Suresh Kumar Antil comes and stems really from the dismay that the court has felt with the overflowing prison population. That really was the first start to it. The conditions in prisons are abhorrent. People don't get jail. The old rule that Justice Krishna Iyer had said, that bail, not jail, was observed only in omission. Certainly the trial courts were not following this very salutary principle, which is really a reflection of the presumption of constitutionality and presumption of innocence. So that is why the court was compelled to do something about it, because every day, not only were the prisons getting full, but the dockets of the court were also getting full. Matters upon matters of bail are reaching the Supreme Court. Now, these are not issues that the Supreme Court should spend any time discussing and deciding and granting bail, because you find the high courts and the trial courts are not granting bail. The time of the Supreme Court is precious. It should be used for constitutional adjudication. Instead, a lot of this time was being used to grant bail to people. So there was a crying need for the Supreme Court to step in and just remind the courts below as to what the law is. We must remember the pyramidical structure that exists in our judicial system, in our constitution. The Supreme Court is an apex court, of course. It is a constitutional court. It is technically coordinate with the high courts in terms of the fact that it exercises constitutional jurisdiction. But by virtue of the provisions of our constitution, whatever the Supreme Court says is binding on the rest of the courts. And it also sets a trend or a message as to what is the right way to go forward. So that is why this judgment has now come. Guidelines are being laid. For instance, one very important guideline is, and we see that was observed only in the exception, was that if someone has not been arrested during investigation, there is no reason to arrest them when they are produced before, after cognizance is taken before a magistrate. So a large number of people who are being pushed into prison, they have to be kept out. And if certain sensible, practical, legal methods and guidelines are laid down, we will find that the load on the prisons as well as the court will come down. So that is really what the judgment is attempting to do, is to lay down a set of guidelines as to when bail should be granted and how the matters can be taken forward. How far the system has changed thereafter, I suppose we can discuss a bit later. I'm sure there has been some improvement, but there is a long way to go still.
There's a long way to go, but there has been improvement, is what you're saying, but we still need to walk a lot of distance. I'll go to senior advocate Pramod Dubey. Now, you also go to other jurisdictions other than Delhi, where sometimes in Uttar Pradesh you go and appear for bails. Do you see a marked difference in how these cases are judged, and why this judgment in that, in a sense, perspective, very important?
Tarun, there is a history behind this judgment, Satyendra Kumar Antil. I would like to mention, in our Delhi, Justice J.D. Kapoor of Delhi High Court passed the order way back in 2003 in court on its own motion. and Justice J.D. Kapoor's judgment in court on its own motion laid down the guidelines. And the guidelines was laid down for the Delhi judicial officers. If the accused person has not been arrested during the course of the investigation, the accused cannot be arrested for the purpose of placing the charge sheet or even after the filing the charge sheet. So in our Delhi judiciary, this judgment continuously being followed, but it was not being followed by the other states. When we were appealing to the other state, they were not giving the lot of value to this judgment because they are saying this is not authoritative judgment, it's only the persuasive and it's our discretion. Then again, the reference came to Delhi High Court before the divisional bench, and it was answered by Justice B.P. Sangvi and Justice P.S. Keji. And I had the opportunity to appear as the amicus curiae in that matter. And our divisional court in court on its own motion second, they confirmed the judgment of J.D. Kapoor and passed the order that this is the good law. What happened thereafter? In Uttar Pradesh, in Siddharth versus State of UP, and I had also the occasion to appear in this matter, this is Siddharth versus State of UP, and the things entirely changed on 16th August 2021 when Justice Sanjay Kishan Kaur and Justice Sundresh passed the order confirming both the judgment of Delhi High Court, court on its motion first and court on its motion second by the divisional bench, and they said this is the good law, and they passed the guidelines. If the accused has not been arrested during the course of the investigation or the filing the charge sheet, they cannot be taken into the custody. So this was the good law. Then ultimately, Satyendra Kumar Antil judgment came on 7th October. And then the categorization of the judgment on the 7th October. Subsequently, Justice Sanjay Kishan Kaul and the Sundresh passed a detailed order on 11th July 2022. And in that, they laid down the guidelines. Not only the guidelines, they gave the altogether different bail jurisprudence, and which has been pointed out by Mr. Kripal, that's a Krishna Iyer's jurisprudence. So the Krishna Iyer's jurisprudence was not being followed. So Justice Sanjay Kishan Kaur passed the order, and he says, no, if the person has not been arrested, no point person keeping behind the bar after filing the charge sheet. This is number one. Number two, Justice Kaur's jurisprudence says there is a difference between the bail during investigation and the post-investigation. So if the charge sheet has been filed, investigation has been completed, there is no purpose keeping the person behind bar. Thereafter, on 3rd February, this is very crucial day, on 3rd February, again the matter came before the Honorable Supreme Court, and fortunately on 3rd February, there were again the bench of Justice Kaul, and Justice Kaul laid down the guidelines, and he showed his pain. He says that despite our direction, some of the state, the judges, they are not following our guidelines. So these judgments should be circulated to the Judicial Academy, and these judgments should be brought in the notice of the judges of the entire country. So this judgment became the law of the land, and there's a category. Once you are deciding after filing the charge sheet, you have to fill up the tables mentioned in the judgment. Ultimately, on 24th March, this is very crucial. Why is it crucial? On 24th March, there was the quorum of 3 judges. Earlier, there was the quorum of the 2 judges. So, 24th, a detailed order was passed, and new jurisprudence was also given by Justice Kaur on 24th March. And in paragraph 5, Roman at page number 11, if you see, there is an argument on behalf of the defense. And they says, sir, you passed the order, even if the charge sheet has been filed, accused has not been arrested, this test would be applicable for anticipatory bail also. So Justice Kaur laid down the regular bail as well as the anticipatory bail. So keeping in view this test of the anticipatory bail, now the Delhi court has also started giving the bail, even anticipatory bail in the PMLA matter and the SFIO matter. Recently, our trial court has passed the order in the Bhushan power, and the bail has been granted, anticipatory bail has been granted. So these judgments are continuously being followed, and this is the drastic change, because Ms. Neha Nagpal will remember when they were representing some of the accused in 2G matters, they tried their best to rely upon court on its motion first, passed by Justice J.D. Kapoor. And Justice Bagriok was having the complete disagreement. So now ultimately it was decided by the divisional bench. Now we have the judgment passed by the 3 judges of the Supreme Court. So now we are having a new criminal jurisprudence on the bail side, and I think this is the good movement, because see, lowering the pressure in the jail and the prisoners or the burden of the judicial officers are one aspect, but ultimately you have to see the right of the accused. You have to protect Article 21 of the Constitution of India. So you cannot put the unnecessary condition. You are not supposed to keep the accused persons behind the bar if they were not arrested during the course of the investigation. Their custody is not required by the investigating agency. And it was, Tarun, we were so frustrated, especially a state of UP, Bihar, Rajasthan, Uttarakhand. If you travel, they don't care. Even they were not giving the respect to the Siddharth versus state of UP. And then Supreme Court saw this anguish on 3rd February 2023. This is the guidelines and this should be circulated. And the amicus curiae has pointed on this gadget. So Supreme Court now taking this entire matter in the altogether different direction to protect the right of the accused.
Point very well. Thanks for explaining how this all happened. I'll take this to Neha Nagpal, founder partner with NM Law Chambers. Neha, the problem that we see many times is, okay, even if you get bail, there is another FIR, then there is another FIR. The FIRs keep coming up and you may get bail in one but get arrested in the other. So while you address your introductory comment where you would speak about justice call and this judgment, could you also address this issue of multiple FIRs being filed? Just getting bail and arrested in the other offense.
So Tarun, firstly, thank you for having me on your show. I think it's Justice Call's judgment in Satyendra Antil has 3 times over, as Mr. Dubey correctly enunciated, has reiterated what the Supreme Court has been saying since the 1950s and 1970s, that bail is the rule, not jail. And seeing the system, during COVID, there was the number of under trials who had to be released on orders of the court, and by setting up state boards to facilitate their release. I think the Supreme Court has always taken cognizance, but it kind of really amplified this issue before the Supreme Court, that here we're dealing with a system where the judicial system is one hand breaking down, as Mr. Kirpal aptly put, because of the number of bail applications which block the court time. Trials cannot start because the judges, even in the lower judiciary, are dealing with bail applications. Then the High Court, then the Supreme Court, and it's really not required. Two, the number of under trial convicts are almost account for almost 2/3 of total prisoners, at least in Delhi alone, which is a very alarming and disturbing number. So I think the judgment in Antil is a very welcome step. In fact, the court has also passed a direction to the government and parliament to consider maybe coming out with a proper code on bail, which I think is a very welcome step. It's a very needed step, because we need to put these things together. In addition to even doing that, the court has also taken recourse and emphasized the potential of use of provision, which is Section 88 of the CRPC, where instead of bail, a bond can be taken, because Section 88 as such serves the purpose of bail, which is on a personal bond. The accused undertakes to appear through the course of trial. And another very humanitarian aspect of the judgment has been where the court has said that under Section 440 of the code, when putting conditions for a personal bond of an amount, be considerate and or if accused have got bail but are still languishing in jail, let's do a review of that, of those who've not been able to meet their bail amount. So I think it's definitely a very welcome step, and it's sort of I could say a code in its own way. And now adding the aspect and extending the principles to anticipatory bail is completely made it a complete code on bail as things stand today. Dealing with the issue of multiple FIRs and multiple bails, yes, that is a big problem. And it causes a lot of anomaly with the system. It causes a lot of frustration. But what Antil does is, look, even if somebody has 3 FIRs, potentially in bank fraud cases against them, it may very well be that they are arrested in one and not the other 2. So automatically Antil applies in 2. Because there is a very specific paragraph in the judgment which says if consciously the investigating agency has not arrested accused person during the course of investigation, that they're entitled to bail under the principles of Antil. So one can obviously use that as aid and support for the matter where they are either arrested, during the course of investigation, or God forbid, post-investigation, to say that, look, if in one case where pretty much the same as happens in bank fraud cases, same company, same time period, similar allegations, and it's documentary evidence. 2 cases he has bail, he's not tampering with evidence. It will definitely buttress their case in the third matter as well.
Point very well taken. I'll take this to Senior Advocate Saurabh Kirpal. Mr. Kirpal, 2 things. Promoters, when they are booked in cases, in many states, the practice is to immediately arrest them. If they employ 10,000 people, the immediate concern is that the company is promoter driven in India. They're not able to pay salaries because, basic things like how money is allocated becomes a problem. Bank loans, don't get paid. It triggers so many problems that many times the companies run to ground. Do you think, of course, there is this whole issue of liberty that Senior Advocate Dubey also spoke about, that was in the context of all accused. But if we just slice it into the commercial aspect where we look India as an economic unit in terms of these people who generate jobs, how do you look at this problem?
You see, I am firmly of the view that this old jurisprudence, because it's now of 2002, 2003, that economic offenses are somehow very heinous, really needs to be revisited. If it is not correct to say that economic offenses are more heinous than rape, murder, dacoity, these are offenses against the person. These are offenses of violence which need the courts to be stringent and not maybe grant bail because the person will come out and do maybe the crime again, or will destroy evidence because the person has shown a violent tendency and can go and do something else. Now, in matters of economic offense, where everything is documentary, there is really no reason whatsoever to arrest anybody. So this is a knee-jerk reaction that agencies have, that first you have an FIR and then automatically go and arrest the person. There is no basis in law or logic for this way of behaving. And you very rightly said that, we have a tendency of looking at business with suspicion. And businessmen in particular with suspicion. And this is a legacy of the socialist era that we had in the 70s. But even in the 70s, when we were in the midst of the hatred of businessmen, so to say, the rule was still that bail, not jail. Now, we moved 50 years onwards. We've had economic liberalization. We want foreign money to come in. We want to ensure that there is a growth spurt in India, that there are green shoots. We want to encourage economy. We want to have the ease of doing business. But simultaneously, if you hang the sword of arrest over everybody, why will a foreign businessman invest in India? Or indeed, why will a businessman in India seek to expand his or her own business? Or most importantly, and this is something that is also should be highlighted, that a lot of business is conducted with the state. A state comes up with tenders, with floats all kinds of contracts. And the moment a private entity undertakes and does some business with the state, you get the provision of the Prevention of Corruption Act, which can get attached. And once you do that, and you in any investigation, there is no public servant immediately identified. They will say, we will investigate and find. But there are unknown public servants. But the unknown public servants are never found. But the private entities who are always roped in, then find it very difficult to get bail. And because they're not getting bail, their businesses start suffering. We've done so many cases. Mr. Dubey and Neha as well would have done these cases, that companies which are doing well are driven to the ground because the promoters are in jail. They don't find it easy to get bail. The resources are diverted from growing a business, or typically you would be arrested at a time when your business is not doing well, say in bank fraud cases or in other corruption allegations. Your business is not doing well, which is why we find that the business people are arrested. The agency is not seeing that businesses can do badly because of other circumstances beyond their control. The assumption is, no, you must have done some ghotala, we'll come and get you. So now there's a double whammy. One is you've been arrested. Second is your business is not doing so well. So this literally, and not giving bail at this point of time, almost ensures that the business comes to the ground. Yes. So I really don't understand how the ease of doing business in India can possibly happen as long as we have a stringent bail process. And to take Neha's point and your point also about Delhi versus other states, Neha's right. In 66% of Delhi's prison population is under trials. In India, it's 80%, all of India. So Delhi is much better compared to some of the other states. So it is quite likely that if you are a person outside Delhi, you would be arrested. You will find it impossible to get bail because there are multiple FIRs. As you said, I'm just joining these points together. You have multiple FIRs. You're in jail for one FIR. Forget not getting bail in the multiple FIRs. You can't protect yourself in trial, which is happening for the other FIRs. You can't protect yourself for investigation, which is happening in the other FIRs, because you have no access to lawyers, which is free. So this is a double, triple whammy, and is a complete violation of Article 21 and 22 of our Constitution. This is really a
point well taken and well explained. I'll take this point to Senior Advocate Pramod Dubey. I want to share an anecdote with you, which you may also know, that a court in Uttar Pradesh had issued a warrant for the top boss of Samsung, was it, in South Korea, over a minor violation. It sent shockwaves to the industry that the India unit of the company would have done some minor customer-related violation, and the top boss sitting in South Korea is summoned. Now, I want to understand from you. You appear in Delhi High Court, Supreme Court, but you also go to UP and other states to appear. A, what difference do you see in the attitude of various courts? Second, do you think judicial training is necessary? Because Satyendra Kumar Antil has come, but do you think judges need to be trained and the message needs to go to the lower judiciary also to give bail? It shouldn't land up at the Supreme Court's table all the time.
See the beauty of the Satyendra Kumar Antil. Not the justice cause judgment says that the judgment should be given to sent to the Judicial Academy and the judges should be given the training. It also says the public prosecutor will not make opposition of the bail for the sake of the opposition. This is number 2. Number 3, the issue which has been raised by Mr. Kripal, that's the economic offences. If you go to Satyendra Kumar Antil July's judgment, Justice Cause judgment says you cannot basically categorize these economic offences and deprive the person from the bail. So far as the corporate sector is concerned, Tarun, one thing must keep in mind. You cannot develop your economy unless and until you give the access to the corporate sector. It is basically, if something has been happened and happened at the lower level, you cannot issue the warrant to the other person, arrest the other person, because the criminal act is the act of the person, not the other person. Vicarious liability, you have to see, you have to test. So you blindly cannot issue the process to harass the person who are at the higher level. Number 2, your second question, so far as the comparing the Delhi with the other judicial system. See, we are in other judicial system like the other state, they are not much concerned what is the judgment being passed by the Supreme Court. Even after Justice Call's judgment, on 24th March, Patna High Court passed the order and Justice Call raised the same issue. Raised the same issue day before yesterday. Despite our order in the Satyendra Kumar Antil, Patna High Court has not complied with.
So this is a serious issue, isn't it?
This is a serious issue. Or not only, this is not only sent to the academy. There must be the issuance of the contempt proceeding, because this is the law of the land. You are overreaching the Supreme Court judgment. Unless and until the court will pass the stringent order, they are not going to comply with. Because you see how the things are traveling. Since Gurbakh Singh CBR, there is a judgment, then Justice Mate judgment of Justice Bhandari, then Arnesh Kumar, then court in his own motion. But still, this is only in the book. They are not complying with, except Delhi. So Delhi judiciary, I would say that Delhi judiciary, they are fully complying with this judgment. And even the PMLA, if the accused appears without arrest, first day, he would be released on bail, and they are granting the bail. They are not keeping inside. Even in the PC Act, they are not keeping inside. So there is a lot of difference between Delhi judiciary and other judiciary, and there is still non-compliance of the guidelines passed by the Supreme Court.
Point very well taken. No compliance of Supreme Court guidelines. But I'll take this question as a closing comment to Neha Nagpal, founder, partner with NM Law Chambers. Neha, should the public prosecutor oppose bail as a habit? That, okay, it is not taken for granted that PPs oppose bail. It's never ever happens that they don't oppose. Second, could you also encapsulate in your answer 2-3 points? Where do we head from now? Since this judgment is out, what is the future? Do you think all is settled, or a lot has to be settled?
That's a very interesting question. So firstly, I think in cases which meet the parameters set by Antil, I think public prosecutors should come of age and be magnanimous and accept that they are not opposing bail. In fact, Mr. Raju, the learned ASG appearing for CBI, last week when Antil was listed before the Supreme Court, made that statement. He said, I'm going to request internally an office memorandum of sorts to be published by CBI for this purpose. And I really think that is going to be a big step in the right direction. And of course, following the diktat of the Honorable Supreme Court. Where do we go from here? Well, in an egalitarian world, I hope that everything, every single court follows the law of the land settled in Antil. Will that happen? Well, time has to testament that, we've had to again and again go back to courts with bail applications. It's not that for the first time the Supreme Court has said that bail is the law and the rule and not jail. But I'm hoping things get better because like Saurabh very nicely encapsulated, that actually I have a client who has 52 cases against him. By the time you finish discussing even 2 cases, whether it's on a VC through, in custody, or one goes and meets him physically, you can't go to the third. So consequently, nothing is moving forward. And that is also one of the reasons that possibly conviction in this country is so low. Because how do you move forward? It's really not possible to get ahead and prepare because we don't know the facts, contemporaneous facts as we call them. It's pretty much the main person sitting behind bars. And how is he going to protect himself, get access to material, even with data, to be able to tell anybody? So I think I hope it's a sincere hope that Antil is followed to the T so that things really do get better, even in terms of management and services and facilities in Tihar or any other jail for that matter. So I was just reading an article over the weekend in the Indian Express where across Delhi jails, inmates have now resorted to filing RTIs to understand what better services or what better facilities.
One quick question before I end the show, Neha, very quickly. There have been some news reports in the past 6 months to 1 year saying that businessmen were found running offices inside jail, where it was found out they're trying to run their business from inside. Doesn't it show the desperation that they just want to run their business in order to pay salaries?
I must put a caveat there. I'm associated with that case, and so I should not say too much here.
Let me jump in and say this.
Yes.
I think it shows an absolute desperation.
Yes.
People don't want to be criminals. No one wants to be a criminal, but you are driving people to become criminals. Then you have to reflect on what it is that you are doing. You talk of public prosecutors. I mean, in Hukam Chand's case in 99, the Supreme Court has said that the public prosecutor owes a duty of fairness, not only to the court, not only to the investigating agency, but also the accused, because you're representative of the state. You must remember that. And that is why this Antil's judgment is of great use. It must be followed across the country.
Thank you. Almost out of time. I would have liked to speak to all of you a bit more, but time doesn't permit me. We will like to revisit this issue with all of you in July 2023, which is 4 months from now, where I think a fair bit of time would have passed and we would have seen whether the courts are taking this seriously and what is happening. But it's a very troublesome prospect when one hears news a businessman is desperately trying to run his business from jail. He just wants to pay back his loans. He just wants to ensure that salaries are paid and everything doesn't go astray. So it is in the interest of the economy. Secondly, it's a very, very fearsome prospect when a businessman is investigated by CBI, ED, SFIO, and also has LOC issued against him. All of that is a very troublesome prospect, which can almost drive a businessman out of India. He'll go to Singapore or wherever, but he'll feel, I don't need to be in this jurisdiction. We must, in a sense, take all of this up from time to time so that things get better only with discussion when things are stirred into debate. Thank you so very much. I appreciate that all three of you joined and gave time on this really important issue. Appreciate it.
Thank you.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.